Today we are going to tackle and explore the very large topic of international law and the various organizations. This will definitely take a while, so making pauses along the way to catch up and to reflect on what you have learned is definitely recommended. So let's get started. To begin with, what is international law? And essentially, international law is law that governs countries. And in a way, it is like a civil law, being that it is a contract from one sovereign nation to another sovereign nation that has been recognized. The differences between domestic and international law is that international law has a body of rules, rules that bind states and other actors in the world in their politics with the relations from one country to another country. That is international law. But unlike domestic law, international law reflects the lack of an international sovereign, a central power authority. And instead, international law can be enforced only through reciprocity or sanctions, instead of an independent country that has a capital city that would administer the laws to the rest of its territory. There is no international legislature to set laws for all nations. Instead, international law is ultimately based on explicit or implicit consent to its participating nations to obey by its provisions. However, some of the sources for international law can be first, customary practices, and this represents the established and consistent practice of states in international relations. And this can be done through diplomatic immunity, the prohibition of slavery, or the abolishment of genocide. When states' adherence to rules becomes widespread and commonplace, they may become regarded as binding to all states, even if there are those who do not explicitly consent. It does become, in a sense, a convention. Treaties are essentially contracts between states. Treaties are formal agreements to accept limits, such as the Lisbon Treaty and the Article 50. Another source of international law can be customary law, which is consent is explicit, unlike customary practice. But if a treaty's provisions are widely observed by most states, it can be argued that these provisions have become customary law and hence then binding international law from one country to another country. What needs to be done internationally, though, is that international law declares that agreements must be first kept and also performed in good faith. A state's internal laws cannot exempt it from compliance of international law, which has caused many problems, especially areas of trade or matters of environmental concerns. Forums and negotiation treaties do exist. There are international organizations such as the United Nations, like the Convention on Chemical Weapons, or multilateral forums like NAFTA, North America Free Trade Agreement, or bilateral negotiations like START. But violation and compliance are different. Unlike domestic law, law within their own individual country's legal system, international law is frequently violated. But many provisions and principles are adhered to by every day, such as freedom of navigation on the oceans. But these are being challenged in locations such as the East China Sea, where the People's Government of China have built artificial islands in an attempt to extend their exclusive economic zone and ultimately sovereignty over that water. But the United States continues to exercise freedom of navigation movement through that water. Most governments attempt to justify their actions in terms of international law, even when their legality is in question. And because of this, there is no international sovereign authority. The legality of an action often depends on one's own point of view, such as if the United States invaded another country, such as what happened after the September 11th attacks, when the United States invaded the countries of Afghanistan and Iraq. Why then do states obey international law? International law provides a framework for orderly conduct of international affairs. It allows states may obey the law out of fear of sanctions or even military reprisal. And military law can be enforced by any sort of reciprocity. States that routinely flout international law may gain a reputation as untrustworthy and may become a pariah or a rogue state there, deterrent, which can be ostracized from the international community, such as the ongoing nuclear weapon proliferation program done by North Korea and the questionable sources of income that the Kim family gets from more sources that are not exactly legal to fund the program, even though the people in North Korea have severe starvation and other severe social issues. The areas of international law can be first and foremost the principle of sovereignty. This is important. The principle of sovereignty formally established in the Peace of Westphalia, and the principle holds that individual states have the ultimate legal authority of their legal system within their own established and recognized borders. That is the principle of sovereignty. States have the freedom to govern their own personal sovereignty, territorial sovereignty, the use of public domains such as high seas or outer space, legal arrangements with other countries and states, and fight wars if it's in the case of self-defense. Sovereignty also implies that interference with domestic affairs is outside the scope of international law, but this can be a cause of severe troubles and problems when it comes to the enforcement and adhering to the idea of human rights, such as what may be happening in Western China with the Uyghur population. Other problems with sovereignty is that actions taken by another state's territory in response of threats to sovereignty can be seen by others as a form of armed aggression, which can be open to sanctions and other international forms of punishment. Once again, like when America had invaded another country for its oil. Some other countries declare that sovereignty allows them to violate international agreements. As an example, when North Korea refused to allow the IAEA inspection of its nuclear facilities. According to the principle of personal sovereignty, individual states cannot be subjected to international law, and the individuals inside that state are not subjected to international law, nor claim any rights under international law. But this can be interpreted to allow governments to treat their citizens brutally, making it difficult to bring to justice leaders who perpetrate violations of human rights, because even though it's international law, it is happening within their own domestic system, which is allowed under the Treaty of Westphalia. The idea of human rights under international law have been inalienable as well as ancient. But regardless of human rights under international law, and where it may go back to Cyrus the Great even, or even earlier than that, the idea of guaranteeing human rights under international law is relatively a new concept. Conceptions of human rights are grounded in the doctrine of natural law. And natural laws, which is the idea that certain human rights derive from a higher law rather than actions of the rulers or their governments. This is something that's been theorized by hundreds of years of various philosophers. As an example, In the 19th century, international law developed a doctrine of humanitarian intervention to stop atrocities. But by the late 19th and early 20th centuries, international conventions on human rights were then signed, such as the Geneva Conventions on Laws of War. Efforts to develop international universal law and human rights were hindered by the doctrine of positive law, which claimed that there could be no law in the absence of sovereignty, and that international law did not apply to the individual sovereign rights. You can see the contradictory loopholes that do exist in international law and the enforcement of it. This doctrine was put to the ultimate practice and test during the Nazi Germany's Nuremberg trials, where they tried to legalize the persecution of Jews, even though Nazi Germany had been defeated. And the former leaders of the Nazi hierarchy were put on trial for crimes against humanity and genocide, amongst many other charges. But after World War I, with the Holocaust in recent memory, the UN codified the principles of human rights into international law, which led to the actual Declaration of Human Rights. But for the rights of women who have acquired a special place in international law, rights of law, these are also unfortunately frequently violated. Women's rights that have become international norms include, though, when not violated, gender equality, equal access to education, economic opportunities, or the prevention of actual violence against women. But this does get violated. But the abolishment of abuses of women, human rights, is difficult, unfortunately, because of various cultural ignorance, such as perhaps what happens in India, the inference of women concerns, and the strong political resistance in some countries that want to maintain the so-called normal. In 1998, delegations from 160 states adopted a statute creating the International Court of Justice, which does have the power to try individuals who have been accused of wars and crimes against humanity, such as war crimes or genocide. Some major states include the United States and Russia, two of the 5 permanent members on the UN Security Council. But the U.S. fears that the ICC would be used as a means to persecute U.S. soldiers, the president, or other high-ranking officials who oppose this. And as a result of that, the failure of the 5 permanent members on the UN Security Council to ratify the statute questions of how this can be for effectiveness. But human rights decrees can be enforced. When human rights have been clashed with sovereignty, sovereignty has usually won out through forms of torture, political imprisonment, can still be widespread. As unfortunately throughout history, we do have a plethora of devices. The conduct of war has been a major area of international law. As with human rights, these attempts have only been partially successful since the Second World War. Some international conventions cover the rights of belligerents and neutrals. Other conventions seek to limit the means of warfare, such as the Geneva Protocol. In Antarctica, 1959 Antarctica Treaty prohibited new territory claims on that continent and declared that it should only be used for peaceful purposes. In 1998, a protocol came to force that bans the mining or oil exploration in Antarctica for a span of 50 years. Overall, international law shows that international system is not completely anarchic, but attempts to enforce international law to resemble a frontier vigilante kind of justice. But the sheriff is weak, all the citizens are armed, and everyone must bring the criminals themselves to justice. But there are international organizations that do help. The international organizations are called upon to deal with political, social, and economic issues when states are unwilling to manage themselves. Organizations, intergovernmental organizations, are associations of sovereign states with a common purpose that is attached to a formal agreement, such as the European Union. Some have a global membership, while others are regional, like ASEAN or the UN. But for the UN, though, there can be also general purpose forums. where they can talk about specific issues. Example like NATO, the largest alliance. NGOs, non-governmental organizations, unite groups and individuals usually for action on specific issues, such as Greenpeace. They lie outside the traditional structure of international policies, but many have significant impact on world affairs, even though they are not officially part of an international structure, such as the United Nations. Now, the United Nations began really with the Concert of Europe. The Concert of Europe was established after the Napoleonic Wars there, and this was done to resolve European conflict and to provide a sense of collective security and protection. Even though there was going to be two world wars fought on the continent, this concept of Europe collective security was still being pursued because of the immense long duration of conflict that was brought about because of the Napoleonic Wars. The concert did not always operate in an impartial manner, though, but it did reflect political relationships between the great powers of Europe: Britain, France, Germany, Spain, and Italy. The elitism of the concert did provide its undoing, though. It was incapable of responding to the rise of nationalism amongst its many subjects or peoples: nationalism, imperialism, the ANOS acronym that would lead to the First World War. But the League of Nations was created at the Treaty of Versailles in 1919 to collaborate and to protect the collective security, to protect the peace. The League of Nations would last until it was formally dissolved in 1946. Arguably, the League was stillborn. The most potently powerful state in the international system refused to join, that being the United States of America. And the League proved to be ineffective for a number of reasons. One, the League members continued to practice balance of power, realpolitik. The US never joined the League. Japan, Italy, and Germany left, and the Soviets were only admitted into the 30s and left a few years later. It was missing some very key, powerful players. The League had its own decision-making rules and abilities, but it was hampered by an inability to take action. And so the enforcement of sanctions from the League was next to impossible. Overall, in the sense of international law, the League was an overreaction of the great politics of the concert. It demonstrated that moral force alone could not stop aggression without the power backing of the great powers. The reaction being what had happened in the First World War, the war to end all wars. But the United Nations was established in 1945 to maintain international peace and security, promote friendly and cooperative relations amongst nations, and almost every nation on the planet belongs to the United Nations. The United Nations founders intend to use it as a world policeman to enforce collective security, but instead the UN has often been an area for political grandstanding. There are some important structures, though: the Assembly, Council, Secretariat, the Court, and the Economic Social Council. There are expectations and experiences from the UN. First, such as the military action. The Security Council can authorize military sanctions in the interest of collective security. While the UN does not maintain its own standing army, even though it's been suggested, it does rely on troops from member states for peacekeeping operations. Since 1948, the United Nations Security Council has authorized 55 peace operations, has sent over 600,000 troops, 1,700 of which have died in these peacekeeping operations. With peacekeeping, there are three types: observing, keeping, or peace enforcement. Peace observation is to monitor compliance with ceasefires or truce. They don't attempt to enforce agreements there. Peacekeeping acts as a buffer between warring parties that have agreed to a truce. In most cases, they can use force to resist. And then there's enforcement, response to the aggression of military force. But unlike other missions, these forces do not require host countries' permission to operate in another country's territory. They are sent there internationally, which allow international law to override the domestic sovereignty laws. But peace operations in the new era have been met with some various mixed successes. As an example, in Bosnia, there was peace observers who generally lacked the capability or authority to stop the fighting and the ethnic genocide that had occurred. In Cambodia, peacekeeping attempted to disarm the warring insurgents, and while successfully supervised an election, there was massive violence. The peacekeepers were unable to convince Khmer Rouge to demobilize and disarm. Provisions for funds for the peace operations may become a continuing problem as the UN takes more and more responsibilities and becomes a bigger and bigger bloated organization. But suggesting on strengthening UN's peace operations through establishing a united peacekeeping budget, pre-designated member states and forces of peacekeeping there, or establishing a $400 million revolving fund for peacekeeping have all been suggested for the UN. But in its effectiveness, though, the UN's founders sought a way to downplay the expectation of the new organization. They gave veto power to the 5 permanent members of the Security Council, and this was intended to allow the UN to take only actions that were supported by all of the major power. This is geopolitics. The UN's effectiveness has been hampered by sovereignty. Sovereignty constrains the UN just as guarantees of civil rights constrain national governments. These are contradictory points of view. Like the League of Nations before the UN cannot force any state to comply with its own resolutions unless the major powers are committed to enforcing UN decisions, usually through sanction or military operations, which can only be sanctioned through the Security Council. Arguably, however, the UN's political and economic sanctions have proven to be effective in some cases, such as the establishing of currently the newest country in the world, which is South Africa. Overall, though, the UN's record has proven that expectations were correct. It acted as a world forum discussion and issues. It has provided and coordinated humanitarian relief and has facilitated collective security when the major powers have agreed. So there are positives. But it has not brought world peace. It was never designed to bring world peace. Some of the greatest challenges in the 21st century will be to adapt its structure and mission to the system. With other NGOs, there is a general purpose, which is promoting regional security, economic collaboration like Arab League, European Union, or ASEAN. The record of these is mixed. They have not stopped widespread conflict, but they have served to promote more communications and more peaceful resolutions with trade agreements. Many of these NGOs have been successful in promoting regional economic cooperation like ASEAN, EU, or the renegotiated NAFTA or CUSMA in North America. Interpol serves an example of how NGOs can foster cooperation among states, but purposes to promote assistance among policing organizations within its own limit. And this is done in the spirit of Universal Declaration of Human Rights. Some specialized NGOs include several groups designed to promote mutual defense, like NATO or the former Warsaw Pact, throughout the Cold War. But by the end of the Cold War, it led to controversy over the expansion of NATO. Many Russian leaders objected to the expansion of NATO, as NATO now covers most European countries. It has made Russia fear that it might be regulated as a second-class power, which has resulted in the president, Vladimir Putin, to take a more assertive and aggressive role in reestablishing Russian interests in Eastern Europe and Central Asia in recent years. But the success of these IGOs have achieved some noteworthy success, like the G7 summits. However, they labor under the same constraints as the UN. Once again, it is all about sovereignty. International law versus domestic law that guarantees their own individual sovereignty rights within their own borders. There are, though, non-governmental organizations, NGOs, which operate across national boundaries and governments. Like IGO, NGO can broadly be focused. There can be humanitarian NGOs like Red Cross, Amnesty International, Oxfam, or Save Children. There can be environmental NGOs like Greenpeace. And then finally, there can be multinational corporations that shows how international law is also connected to globalization and even the global village, which are firms that are based in one specific home country but conducting business in several other states. Some multinational corporations have assets greater than most sovereign countries, like Apple. They are often, and more correctly, accused of political meddling, such as General Motors, Exxon, or Mitsubishi. But the main point is, international law is governed by treaties and how countries interact with each other. And while there is no supreme sovereignty, centralized rule, the UN does have considerable influence in the behaviors and interactions of one country to another country. But because of the Treaty of Westphalia, there is a constant legal tug-of-war between the interests of the international community versus the guaranteed domestic sovereign rights of the individual countries. It is a very large and complex topic, but something that is definitely worth understanding in the globalized world today, and a world that also is grappling with the COVID-19 pandemic. And that's an example look into international law.